Imagine a person surviving 13 years in a vegetative state. Machines were responsible for keeping his body alive, but there was no possibility for recovery. And in such a situation, should law force to continue life, or should our constitution give the provision to right to die with dignity? Supreme Court has finally gone ahead and given their verdict and answer to these questions in Harish Rana case. Hello everyone, welcome to Vajram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are going to talk about Supreme Court's landmark verdict where the first case of passive euthanasia has been allowed by them. So when we are talking about this verdict, what Supreme Court has done, Supreme Court has issued their first ever order that withdrawal of life support for Harish Rana can take place. Now when we are talking about withdrawal of this very support, it is for a patient who has been in a vegetative state for 13 years. There is no scope of recovery, and the parents and the family that has been involved, they have been exhausted financially and emotionally, and that is why they had filed this petition. Now, for this very same case, Supreme Court has clearly said that Delhi's AIIMS hospital will admit Harish Rana and they will be the one to provide all the necessary facilities so that the withdrawal of the life support system can take place. And now this judgment has been given by a bench of Justice J.B. Pardiwala and K.V. Vishwanathan, making it a very important judgment when we are talking about euthanasia and especially passive euthanasia cases. This is going to be a benchmark where a clearer understanding of guidelines and clarity has been brought in. So let us try to understand everything around it in detail, starting with what exactly is euthanasia, passive euthanasia, and then we will be moving into other dimensions as well. So when we are talking about euthanasia, it should be seen as practice of killing somebody without pain. That means a person who is suffering from a disease and that disease cannot be cured, then we are allowing them to die. In a way, in multiple ways, it is taken as a practice of killing. In most of the countries, it is illegal as well. So when we are talking about active euthanasia, it is a process, it is a practice where actively some medicine through injections or some drug is introduced into the body to facilitate the death. But when we are talking about passive euthanasia, in that case, we are not introducing something, we are not injecting something. What we are doing here is withdrawing or withholding the life-sustaining medical treatment. So as of now, if you are talking about Harish Rana's treatment, the life-sustaining treatment that is going on, that will be withdrawn and that will lead to a natural death. So death is not being caused here, it is only withdrawal of the life-sustaining mechanism that exists. For example, turning off the ventilator machines or feeding tube that is gently, gradually removed, or medications, they are put aside. So this is where passive euthanasia comes into picture. So when we are talking about euthanasia and their various types, if we look at it, we get to see active euthanasia is direct act which causes death and it is presently illegal in India. When we are talking about passive euthanasia, back in 2011, passive euthanasia, especially in Aruna Shanbaug case, got some relevance, and as of now, it is legal, but it is being placed with certain safeguards, which we will be talking about. And when we are talking about of doctor-assisted suicide, that is basically providing means to end in life, that is again illegal as of now. So in India, only legally permitted euthanasia is passive euthanasia. That too, very strict, clear guidelines have been put in to ensure the safeguards. Now moving ahead and understanding more about this in terms of constitutional basis. So when we are talking about constitutional basis, we have to move towards Article 21, which gives the right to life. And this very article, which talks about right to live with dignity, judicial interpretation has expanded this to right to die with dignity as well in certain circumstances. Supreme Court has clearly clarified that if we force a person to remain in a permanent vegetative state where there is no scope of recovery, no possibility to be cured, then we are violating their human dignity, which goes against their fundamental right. So if we are artificially prolongating their life, that means we are making them suffer. And that is why, with that thought, passive euthanasia is viewed as a part of dignified end of life care. Now, when we have understood the constitutional basis to it, where it comes from, it is also important for us to look into the legal framework of passive euthanasia through which this particular judgment has come across. So, when we are talking about the living will and advance directive, we also need to know where did this come from. For this, we will look into the previous Supreme Court judgments. So, evolution of euthanasia sparked the debates around Article 21, right to die, and also that where does law and constitution put up in terms of assisted death, which is widely illegal across many countries. Only limited number of countries allow euthanasia in any form. Can you tell me in the comment section which are the countries where the practice of euthanasia is legal? For India, this debate, the evolution of euthanasia jurisprudence, came specially around 2000s with Aruna Shanbaug Case. So this was the first time in the judgment in 2011 that passive euthanasia was allowed for the first time, and clear guidelines were given that a proper High Court approval would be required and medical board will also review this. Now 7 years later, now when euthanasia, the debate around it, the clarity around this was evolving, 7 years later, Constitutional Bench went ahead and clearly recognized it as a fundamental right. That right to die with dignity is part of Article 21, and if a person wants to sign a living will, that if in future they are in a state where there is no scope of recovery, if they put it on paper, they put an advance directive, then that can be facilitated. And that is why when we were talking about legal framework, we talked about living will and its advance directive. So Supreme Court in 2018 allowed that individuals, they can create a living will. Basically, they will put it in a legal document that if life support treatment is not working on them, then it should not be continued and doctors will be allowed to withdraw life support system. Now, this living will, idea of living will, was also facilitated with safeguards, such as the decision to be reviewed by medical board. Then the consent of family and also guardian was involved in this, and proper ethics oversight of hospital was put in place. So this will ensure that patients have their autonomy, but at the same time this will also ensure that there is proper medical accountability as well. Now after 2028, to bring in more clarity in terms of euthanasia, especially now after 2018, especially to bring more clarity about passive euthanasia which was allowed in our country, 2023 we saw Supreme Court coming out with a proper clarification where they brought a very clear and simplified procedure that how living wills will be implemented, and they also made sure that bureaucratic approvals are reduced. Now when we are talking about this particular case, this was different where back on January 15, Supreme Court clearly went ahead and said this is a very difficult case and they would need some time, and that is why the judgment was given today. But when we are talking about cases of passive euthanasia, what we have seen is that these cases have created the legal basis, all the cases that have been present, the judgments that have been present for the Harish Rana ruling, where Supreme Court took time, understood the depth of the situation, the gravity of situation, where they will be allowing withdrawal of life support which will lead to death. So that is why Supreme Court asked for time back then in January 15, and now they have finally pronounced the judgment. And that is why the Harish Rana case and the Supreme Court verdict becomes immensely important, because this is the case which has set the operational precedent. That means passive euthanasia guidelines have been implemented in real time, they have been implemented in real case, and they are operational. This will also strengthen the right to die with dignity, which was operationalized, which was brought into the picture back in 2018. And this will also bring a lot of legal clarities for medical boards, for doctors, and this will directly reduce, because of that clarity, it will directly reduce the criminal liability which is present, especially when we are talking about end of life decisions. And this is where we get to see advancement of medical ethics as well, because this is where there will be a lot of encouragement to palliative care. So when we are talking about palliative care, it is basically a specialized medical care which focuses on reducing the stress, the pain, the symptoms, especially in very serious illnesses such as cancer, such as heart issues, and it will also bring in a lot of encouragement to humane treatment. And all of this will also have an impact on the policy landscape, because policies around end of life care, what kind of laws end of life care would need, that would be brought in. What about a euthanasia legislation? Because as of now, what has been the legal framework? It has been set up pretty much by judicial oversight. What about a proper legislation where the parliament, where the lawmaking body sits together and considers it as an aspect of our society, the real cases? Harish Rana is just one of them, where a final relief to a undue suffering that the person was seeing in vegetative state can be expected, the prolonged stress that the family went through, and this is where a lot of such cases might be present. They might also get some relief, they might also get some sight into it when policy landscape tries to address it. Now that was all from my side. Now I'll be leaving you here with a prelims practice question. You can put down your answers in the comment section. Thank you so much.